Well, Mr. Baseman,
Good afternoon.
Mr. Sessoms is on his way. I see. This is going to be the battle of the marks.
Mark the spot.
Okay, you're up, Mr. Sessoms. You're the mark who goes first.
May it please the court. I have the honor and privilege of representing Sarah Gerber, and I would reserve 3 minutes provisionally. I may use reserve less in the final analysis, but 3 minutes at this point in time against the responsive argument. This case is unusual because it involves the interplay of faith and money and how each affected the other. And so I'm going to go through some background, which I think is critically important. I don't know that the facts are considerably in dispute, but I want to frame the issues by at first addressing the facts. So my client hails from Toronto. These parties are both Jewish faith, Orthodox Jewish. They're both Chabad Lubavitch, if you're familiar with that movement. And they met through third parties and dated approximately just a very short few weeks. And
let's use your time to talk about the legal issues. Your party, they met a couple of weeks before they got married. They moved to New York. They lived in Brooklyn for a year or so. They moved down here. They have these 3 kids. They've been at the temple. We got it. So I want to talk to you about the relocation issue.
yes,
Your opponent argues that your request for reversal is not well-founded because your client had already lost the temporary relocation, trying to go to Parkland. And this happened, 6 weeks before trial. You had just appeared in the case and filed your motion for leave to amend. And the husband argues he was prejudiced. It's been withdrawn. She's all over the place. She wants to go to Parkland. She wants to go to Lakeland. She wants to go to Orlando. And the trial judge agreed with that. So he says that fundamentally on the merits of it, that your client didn't make a showing, and I think this relates to the original temporary reload petition, that reload would be in the best interest of the children, not just the mom, and that if there was a mistake in denying leave on this, that the error was harmless. And I think that argument goes, well, she can petition for reload anytime. I don't think it takes into account that petitioning for reload post-judgment there's a different threshold showing required. So talk to me about what's wrong with your opponent's arguments on the denial of leave for relocation.
So first and foremost, the rule requires and the law supports that amendment is to be liberally required. So temporary denial of relocation is not binding on the court. The law is clear. I don't think counsel takes issue with that. It's not binding to a final analysis. Counsel indicates, I think improperly, that somehow the request to amend is futile because the issue, he says, is simply my client wanting a different economic alternative. That discounts the whole facts, which I was trying to allude to, of my client is a teacher by profession. She can make $82,000 down in Parkland. She can make, $54,000.
She can't teach in a secular public school here, and she's not prepared to go seek the education to do it.
Correct.
So I get it.
So that dovetails with the statute. What counsel ignores is the relocation statute on its face says specifically that the court is supposed to consider because it affects children. It's not simply, is the child better off by going all this way from the father? I get that part, that's his argument, but it ignores the fact that my client is not to be made a prisoner if she can't work in her profession, which she is bound to do by her faith and by her entire history, when she married the husband.
And not to cut you off, because I read your argument on it, but I want to use your time as best we can, and there's more issues. Part of what you're saying, if I'm reading your brief correctly, is that if reload goes forth as your client has proposed, if that's considered and she's actually successful, it's going to change the alimony landscape significantly.
Significantly.
Because she's going to be making more money in any of these situations than they made jointly for all these years.
She would be self-sufficient, which is the point.
And I think just to make sure I understand, because some of this is more implicit than explicit in the briefing, but I cut you off. You're saying we're not looking at the best interests of the children entirely in the abstract, both from a financial standpoint with regard to the mother being able to earn a better wage, but also given her faith that she wants to be productive and that keeping her here where she doesn't seem motivated to work at the Hebrew school in Tampa is detrimental to the children as well. Did I read that correctly out of your brief?
In part. The other issue is obviously her mental health is threatened by the fact that she testified she's been shunned in this very small community of 5 families where she lives. And counsel says, well, you could live in any of these other 10 communities, which are peripheral, but in the geographic area of the Tampa mission, if you will. But all of those communities are just a rabbi and a wife and whatever children they happen to have. For her to be involved in a community and have the breadth and joy of life, she's going to have to move to go to a different community because of the specifics of the facts of what happened and caused these parties. I'm sorry, Judge Northcott, you're raising your hand.
Well, I was going to say whatever. Well, actually, I was doing this,
I
but I thought it had come to mind. But whatever the arguments are about whether she had a good reason, whether it would be beneficial, the trial judge did not hear this evidence or those arguments in the final hearing below, correct?
Not at all.
The motion to.
Not at all. And in the trial, in the temporary hearing, it was just a truncated version of it. You realize,
Right. No, how
I
they go.
cited very specifically, the trial judge ruled within minutes of the conclusion of a 2-day hearing. I mean, obviously, the die was cast from the start of it.
So
Well-
accepting that there's been no formal proof as to these issues presented to the judge, although, there's some of it can be gleaned from what was in front of the judge. My understanding that the element of a motion to relocate necessarily includes it will be good for the children, or is it there has to be the person requesting the relocation needs to have a good reason, and then also the move will be either beneficial to the children or not detrimental to the children. Correct.
The total gloss is beneficial to the children. But
you don't have to say, I need to move to Orlando for the benefit of the children. You can say, I need to move to Orlando for these reasons, and it will not harm the children, and in fact, will benefit the children.
Correct.
Okay.
Which we did. The other reason counsel says,
or what you tried to do.
What we tried to do. What we tried to have heard in maybe a different proof was in part what was dealt with at the temporary hearing. I think counsel just focused on, at the temporary hearing, different counsel obviously, just focused on the economic effects, but
right.
It would just short shift to the other issues, and they needed to be fully developed. You're mandated as a trial court to hear those temporary relocation hearings within 30 days. So the court has to glom that onto a already crowded calendar. It is difficult to get sufficient time, whereas this trial
there hasn't been discovery and so forth and so on, basically.
Right.
And the other part of this is that the initial petition for temporary reload to Parkland is all well and good, right? But what she was focusing on now, and it's a little bit of a moving target, I can see the husband's frustration with some of this. The paper that you were traveling on was, oh, look, we have this in Orlando, but it's in the alternative, or Parkland is, we still have the Parkland situation. So he's saying, well, most of this was looked at least insofar as reload in the absolute in the first request, but there's a whole different complexion with Orlando, because if I recall the record correctly, part of the concern with Parkland was traveling on the Sabbath, and of course the wear and tear on the kids of that level of travel to and from South Florida. You didn't have the opportunity to present the evidence of what the Orlando model would look like. Am I right?
Correct. Not at all.
I have one more question for you, and I'll try to be quiet for the rest of it.
Oh, We know you, Judge LaPorta.
The issue on alimony, she was denied alimony, and there was and I just need you to help me with this because I don't remember. One of the issues was she didn't plead for all forms of alimony, but her pretrial memo, if I'm not mistaken, asked for exactly the alimony that you now are contending she should have. And I'm looking up. She didn't plead for bridge the gap, but it's in her pretrial memo. And in his pretrial memo, he says she asked for all forms of alimony. So I'm confused. Did I miss something? This record's huge. There's a lot going on. And if she didn't plead for it, does having the husband acknowledge it and having her in the pretrial memos, does what they did in the pretrial memos cure a failure to plead or set up an estoppel for the husband?
Well, it would create a trial by consent. So yes, it would create a waiver. I'm not looking at that petition. I'm not looking at the pretrial memorandum, but if the former husband's pretrial memorandum says that, and we tried the issue of alimony, and the court said, I would have given it to you if you'd asked for it, clearly that would be a waiver. And
obviously, I'm asking this for the benefit of your opponent as well, right, because I want to explore that. But I said I was going to be quiet, and now I will.
Okay. So I think we've covered the issue of the relocation. But one thing that we haven't dealt with is the issue of prejudice. There's no real prejudice that's legally cognizable that was raised because the issue of the move to Parkland was already fully vetted, and the now former wife's deposition was set already, where they could have inquired about Orlando before the trial. So they had ample opportunity to take the necessary discovery prior to trial. So I think now we've vetted the issue of relocation fully, other than to say that case law is that—
I said I was going to be quiet, but
yeah, somehow I knew this was coming, Judge LaPorta.
Judge Northcutt warned me, so I'm not surprised.
The question I have for you is, and I think this is what you're saying, the prejudice that the trial court seemed to be focused on was, we're 40 days out from trial. We're all the way down the road with this case. Both sides of this thing. The trial judge got one thing absolutely right. Both sides way overspent, and for a divorce of this nature. So the Rona's disease characterization to me was spot on. But that alone, the prejudice element, and we talked about this in an earlier case, is generally evaluated from the perspective of the opposing party to be able to prepare in time for the dispositive hearing or the trial. And here, as you're saying, you had pretty much developed or had the opportunity to develop most of this information. And that's not what the trial judge focused on. Am I missing something?
No, it's not what the trial judge, we don't know what he focused on. He just said it was too late. Now, counsel says in his brief, well, hey, you weren't even ready because you were asking for continuance. We were asking for continuance to deal with the issues of custody, and were completely denied despite their filing their trial list, their witness list 2 weeks late, and despite the fact that there was all these high holidays and religious holidays where everyone in the case, litigants, stopped communicating. They were, literally, you can't get a hold of them during these holidays at all because they're prohibited from discussing electronically. So all these witnesses and parties were unavailable. So there was no question that we were, prejudiced by that, which led to some of the agreements that we had. But the agreement on time sharing is conditional, obviously, of no reversal. So if I've covered the issue of relocation, I'll turn more in depth to the issue of alimony and attorney's fees. The husband, they said it somehow—
If I may, Mr. Simmons, because I know you probably have a few minutes left, let me focus a little bit about your position that the former marital home should not have been sold. If you could just comment on that.
So typically, Mr. Baseman raises the issue of it's very unusual for there to be lump sum alimony of the home. Because of the complete conditions of this, my client being deprived of the opportunity to move and be self-sufficient and limited to the earnings of $28,000 a year, which is below the poverty line with 4 children. She didn't have any choice in the South Tampa area where these kids go to school, but to live in that house. That's why we focused on that house. The court said that we didn't adduce evidence. We have the financial affidavits of the parties. On page 108 of the transcript, we go into the issue of how much money there was during the marriage. there was no question that these parties outspent what they had from their respective teaching positions, and also with the parsonage and with the debt. It was over $100,000. We agree. I think it's more like $104,000 of debts. But she needed the lump sum alimony of the house in order to essentially survive and have a place to live and have some stability for these children. The court doesn't even address the issue of award of the home as an incident of child support, and the court didn't allow the lump sum alimony because the court was more focused on debts. This court is
But if the home has been sold,
home sold. This is moot.
so it's moot. I mean, there's nothing we could do about it.
There is something you can do about it, and that's to reverse and remand it for a trial, a new trial as it relates to alimony, and to allow her to amend so that we can see whether the court would allow her to be self-sufficient, which we submit would be beneficial to the children, to have a mother who's fully
But
functioning.
a remand for a new trial would have nothing really to do directly with the home other than
Correct.
the
Home's
effect of
gone.
the sale on the party's financial circumstances, correct?
Home's gone, that's been fully complied with. The debts, the parties have been relieved of their debts. They've received the balance of the net proceeds from the house.
Right. Okay.
So the remedy that you want, if you could get your wish list, it is if we send this back for leave to amend on the petition to relo, that necessarily what's going to follow because of the change in her income, if that is granted, will be a revisitation of the alimony issue.
Revisitation of the alimony, the child support, because alimony changes child support, and the issue of attorney's fees. So simply because the court thinks that there may be RONA issues. Now, remember, that hasn't been fully vetted of why the fees were what the fees were and what exactly the fees were and what portion was to buy this new vehicle for my client and to pay her living expenses, since the husband only paid child support for a period of time. He wasn't paying child support when the trial happened. He wasn't paying it initially. So she got.
And he explained that the reason he wasn't doing that was either she got a tax refund and or he cashed her out of something else, right?
He claimed he wasn't doing it because she got a tax refund, which is far less than what he was paying if you add up all the months. So he didn't just say, okay, the tax refund was this, I was paying this, and when we equal the tax refund, I'll start paying again. He didn't do that. It also just doesn't address how that might have impacted child support. And in addition, there were the payments on the house that he was making on a temporary basis. So it wasn't that he wasn't paying any child support, any support. It was inadequate in terms of taking care of expenses. So some of the $200,000 from her parents related to that. So that all that has to be adduced. But remember, even if the court finds that both parties over litigated this, the court can still say there's still a component of this that's reasonable and necessary and should be compensated. We've now had an appeal.
Mr. Sessoms, you're at your 3 minutes, so proceed as you please.
I count actually, according to my stopwatch, that I'm at 18 minutes. So I'll stop and let Ms.
Yeah, well, you know, I'm trying to give you a little something because we helped you, you know, Judge LeBrit especially helped you use up your time.
Wonderful question, so.
All right, now for the other mark, Mr. Baseman.
Thank you, Your Honor. I represent the husband, Mr. Dubrowski, in this case. I expect I'm going to get a lot of questions, but I do want to clarify two things very quickly. We have not taken the position in our brief that the wife didn't plead for types of alimony. And I believe what the trial court said in the final judgment was that there was no demonstration that any or specific request that any type of alimony and any amount of alimony would be appropriate in this case. And that's why the trial court, one of the reasons.
I thought he said, I would have been inclined to grant bridge the gap, but she didn't plead for it.
He may have said might have been inclined for bridge the gap, but I think the same logic would apply, that there was not a specific request. There was no specific showing of need. The trial court is pretty clear that the wife essentially said, I just want the house as lump sum alimony. And the court said, lump sum alimony is not a type of alimony. You haven't shown a monthly need that should be reduced to this lump sum award. I also wanted to point out that nowhere in the brief are we arguing that because the temporary relocation was denied, that has any effect on whether the amendment would be
Then
filed.
what was your futility argument?
The futility argument was that, and I would say that is the bottom of the barrel of the arguments we're making, but the futility argument was that it wouldn't have even passed pleading muster, the way they presented it. The relocation statute is about needing to go to a specific place and that being in the children's best interest. I don't believe the statute contemplates saying, I just need to get out of this place. And that's more in the nature.
Well, I need to get out of this place so I can work and improve the financial situation of everyone. That means something. And I think we need to keep our eye on the mark here, which is, what is the standard for denial of a motion for leave to amend? It either has to be shown that the amendment would prejudice, that the privilege has been abused, or amendment would be futile. You're saying futility is, maybe ephemeral here, but, have you, I don't think the trial court made any findings on abuse of the privilege. I think it was focused on the prejudice of ostensible prejudice of having this brought up after she'd withdrawn the petition earlier and we're 40 days away from trial. And I questioned your opponent about what the nature of that prejudice, and I'll cut to the chase with you. Why shouldn't we follow the contours of Hall versus Hall, where the petition was denied 30 days before the trial date and there was no showing of futility or abuse? And like the party in Hall, your client's known all along from the beginning when she filed this Miami or Parkland petition that she wants to do this. So it's sort of like, what's really going to be a whole lot different that your client didn't know about or couldn't be prepared for? Where's his prejudice?
Well, the key difference is it's not that the court denied the temporary relocation and that was with prejudice or took it off the table. She then, if you recall, moved to amend with the express purpose of removing that request. And trial was originally continued so that she could amend to remove that request. So she actually pulled that issue off the table. My client absolutely, for the last 8 months or so, and I'm not sure exactly about that timeline, he absolutely thought that issue was completely off the table. No discovery would have been done. In fact, if he had done discovery related,
forget what you did. I think you represented him in the trial court. You didn't forget. Oh, okay. Sorry. Mr. Sessoms was the only one, and he was only there for a short period. But counsel didn't forget what the bona fides of a meaningful opposition to the reload petition were going to be. And they would translate across the reasons what's in the best interest of the kids to stay in Tampa, yada, yada. But none of that was, buried away in a vault that would require a submersible to go get and defend 40 days later in August through October of 2022. So I'm really focused on where exactly is the prejudice to your client. And you've said, recognizing there's a different standard post FJ, that, she can do this at any time. Well, she did do it then. And I'm struggling with the prejudice part of it.
well, just to clarify, I don't believe there is a different standard post-final judgment. My point
Well,
is,
don't you have to show material change in circumstances?
no,
or
the
something?
statute substitutes for substantial change. It's exactly the same standard post-judgment. They could have been moving for that all along. To go back to the prejudice, she added another city she wanted to go to. And she added—
Which is much closer to Tampa.
Right, but she added also, so originally she says, I have this job offer, here it is attached. Now, that's stale at that point. That needs to be investigated. She then, in my recollection, says, or I could go to Orlando where there are jobs available where I could make something like this amount. No job offer attached. It's a very vague statement. More discovery would have to be done. This is, I believe, after all the discovery deadlines. This is after the pre-trial.
The judge had said, and I know you made some argument about the prejudice from now, you're looking at two potential areas. And what could the judge have said? I will grant the motion to amend, but you got to choose one place rather than this close to trial. We don't want to have discovery about the whole state of Florida. Could the judge have exercised discretion to limit the choices?
I mean, I think the judge could have exercised the discretion to allow the entire amendment. So,
well, yeah, but what I'm saying is, so the judge could have split the baby, so to speak, in terms of what the stuff that you were complaining about or your side was complaining about at that time.
I suppose the judge could have. I can't think of a reason the judge couldn't have done that. It was never proposed.
No, I get that.
Certainly, Mr. Sessoms could have said, if your concern is this new Orlando, we'll walk away from that. That may
terms of-
make a difference.
In terms of the procedure, any procedural differences between seeking to relocate during the dissolution case and after, are we still under the statute? And I, frankly, because I don't do family law all the time the way I used to and the way my wife does, are we still under the statute that says you given, you notice of intent to relocate, and then the other side has the burden to object to it, but there's not a change of circumstance issue there. Is that correct?
Correct. It's exactly the same standard, exactly the same procedure. Nothing is different at all. And, when I raised this issue in my brief, Mr. Sessoms' response and his reply is, well, the reason it needs to be done now is because it's intertwined with alimony. But he's conceded in oral argument, and I believe at trial, that if she relocated, she'd be self-sufficient. So the alimony issue is not intertwined with the relocation.
Well, if we agree with your opponent that the trial judge needs to look at the relo, and just hypothetically, the trial judge decides in her favor on that, doesn't that change? Doesn't that put your client in a slightly, doesn't that put your client in a better position from the standpoint of the alimony issue? Obviously your best position is that we issue a per curiam affirmance, but if we send this back for relo, doesn't that sort of put this back in the trial court to make a final determination that, at least under the suggestions that have been made in the briefing, takes a lot of the heat off of the alimony?
Well, only if you reverse on the alimony. If you affirm the denial of alimony, then whether it's referred back on relo or whether it's PCA'd and they just petition to relo now, makes no difference. They have said if she relocates, she won't need alimony. His exact words were she'd be self-sufficient. So yes, that's true. If this court reverses on the alimony for reconsideration, then my client is potentially in a better position, theoretically, because the relocation would take that off the table. But obviously my position is that the trial court did what it had to do on the alimony, and I'm happy to segue into that if the court's ready to, but I don't want to cut off questioning on this issue.
Let's
Sounds
talk
like-
alimony.
Actually, Mr.
No.
Baseman, can I just ask you one question regarding the relocation? Because Judge LaBritte mentioned about the issue of prejudice by failing to proceed with allowing the former wife to request the relocation. Is the fact that by her, the prejudice itself, because right now, post-judgment, as you know, the burden becomes higher for her to prove that the relocation would be more appropriate. Is that sufficient, that showing a prejudice, for us to reverse this case for the consideration of her motion to relocate?
I respectfully do not agree that that's the law. The standard is not higher post-judgment for relocation than it is within the case. Mr. Sessoms didn't argue that, and I believe Mr. Sessoms would concede that in his rebuttal. It is the exact same legal standard within a divorce case as it is post. And it wasn't, because the amendment wasn't allowed, there's no argument that this was already decided on the merits. They can come right back. Like I said, they could have been pursuing this for the last year while this case was on appeal. They can file a petition tomorrow for relocation. It changes nothing.
Thank you.
So one thing I really want to touch on in the alimony argument is the idea that this is not a case where either party ever supported the other party. And the record shows that if it was a case where one supported the other, for the last 2 years of the intact marriage, it was the wife supporting the husband. The idea that we should just, as a knee-jerk, say that this is an alimony case because she doesn't make a lot of money, that is not the purpose of alimony. The purpose of alimony isn't to equalize people's incomes. It's not to divvy up future income. It's to take somebody who was living off support and the promise of support during a marriage and ensure that they're not cut off and the support doesn't end. That was never these people's lifestyle. And, you know, the idea that we should just assume that a wife who doesn't make as much currently as a husband is entitled to alimony is simply not what the public policy about alimony is for. So I know I make that point briefly in the brief, but I do think that's important. There's not even a threshold showing in this case that it would have been an appropriate alimony situation. On top of that, I understand the argument that the trial judge finding her monthly needs to be in the 900s is a low number. I don't know what the court was supposed to do, given that there was no competent evidence of her needs going forward. And as I point out, Mr. Sessom says, well, you could at least take the evidence of certain expenses on the husband's financial affidavit as, and he literally lays out a handful of them: the mortgage, the water, the electric, etc. And you could say, well, that must have been the marital standard of living. She at least has those needs. Well, even if you include those numbers, as I point out in my brief, her monthly need is still below the imputed and the unchallenged imputed income that she walked away from this case with. So even if you add what Mr. Sessoms is saying the court improperly discounted, there still is no need for alimony in this case. So again, I don't think Mr. Sessoms has included enough in his brief to show a financial need, but also I don't think there's a threshold appropriateness of alimony in this case. And I think that's worth paying attention to, and not just doing kind of the knee-jerk that this is a wife and she doesn't make a lot of money and therefore alimony is appropriate in this case. I don't know if the court has any questions about that. Like I said, I'm happy to entertain them, but if there are none, I don't need to spend any more time on any of this.
I think that's it.
I'm fine to yield at this point. Thank you.
Okay. Okay, Mr. Sessoms, I will let you have your whole 3 minutes since Mr. Baseman gave up the rest of his time.
Thank you, Mr. Baseman.
And Mr. Sessom, did I read your brief wrongly? But I thought there was an argument that she'd be severely prejudiced by not going forward with her motion to relocate.
I mean, the issue is more practical than it is illegal. On a post-judgment issue, courts interpret the need to be extraordinary. The courts look at a final judgment as a piece of stone. It is res judicata. We hear that over and over and over. Legion are the cases that are simply knee-jerk affirmed. We need the court to set the standard for the relocation. Counsel is arguing something in his brief that misstates what the criteria are in the statute. The statute simply is what is best for the children, not to the exclusion of how the parents' needs impact the child, as we've talked about financially and part of being a community. So we've talked about those issues. So I would submit to the court that procedurally it is not the same animal at all. And so we've awaited this court's ruling so that we can have that critically addressed. In terms of the issue about Bridge the Gap alimony, Bridge the Gap is not going to suffice for my client. I did look at my pleadings, or the pleadings we were traveling on in the pretrial memo, and it asked for alimony in all forms. So I think the trial court was either mistaken or confused in that regard. And this statement that somehow the standard of living wasn't shown is a red herring. There is a financial affidavit that my client filed on October 13th that lays out what her needs are in this house. That's the standard of living. The court could simply say, I'm going to order the house sold, but I'm going to use the mortgage amount that you're currently paying and these expenses because those are the mark of what the standard of living is, and I don't want you to exceed that, even though in South Tampa it would greatly exceed that. I think we all are privy to that. So the need was expressed by virtue of the financial affidavits that were admitted into evidence. The word standard of living is addressed on page 108 of the transcript, where we go through what the expenses were on a monthly basis. These people exhausted their income. They exhausted their income on their needs. And that's why these financial affidavits show the needs that are off the scale in terms of what their incomes will support. There is no case law that Mr. Baseman references at all that somehow when there's a need and an ability to pay, that it has to be ignored by the court because the husband was not supporting a traditional wife. That is completely contrary to what Kanakaris states in all the cases forward. So he has, and respect to him for getting a financial services job and making $80,000 a year. But my client has been held to this artificially low $28,000 of income because she can't fulfill her job requirements because of the husband's request of the trial court. And to say that she can't get alimony because he never earned $80,000 before the separation is a misstatement of law without any reference to any authority that supports that in any way, shape, or form. So I would ask the court to ignore that. As I said, faith impacts money and money impacts faith. And my client would like the ability, especially given that the relocation statute does not say anywhere that you have to only allege one location that you're going to go to, as the former husband argues. It says that exactly nowhere. And so my client pled the alternative for the reasons expressed about the wear and tear on the kids from the distance and the issue of how do you drive on holy days and how are you going to handle that back and forth given the distance, to plead in the alternative. It can be done even from Parkland, but it can be done easier, although my client income will be less than the former husband's. But the court can address all of these issues on remand if you will make it clear to the court what is going to occur. But it readily appears from the record in its entirety that this result was predetermined, both in terms of the trial court announcing at the pretrial conference that this home was going to be sold, because of the short shift that was given at the relocation hearing, because of the complete denial of alimony and a pained analysis that strained and ignores common sense, that this judge decided at the very onset what the end result would be. So we would ask the court to reverse in total, and think it would be very helpful for the court to issue specific directions as to the law on relocation and as to law on alimony, child support, and fees. Thank you to the court.
Thank you both very much. It's good to see both Marks today. I don't see enough of you guys otherwise, but in order to leave our virtual courtroom, you click the leave button on the Zoom screen.
Excellent. Have a good day, everybody.
Hey, take care. And with that, oops, we've lost Judge LeBrit. With that, we are adjourned.